My name is Professor Glen Luther. I'm a member of the College of Law faculty. I'm also an associate member of the Department of Psychiatry in the College of Medicine at the University of Saskatchewan. My main areas, most people would see me as the criminal law guy, but I teach criminal law and procedure, I teach sentencing, I teach evidence. But one of my real passions has become sentencing law and mental health law, and that results in my connection to Dr. Mela.
My name is Mansfield Mela. I'm a professor in the Department of Psychiatry. I have an associate professor appointment in the College of Law. My work entails assessment and treatment of those with mental disorders that cross the interface of the law, committing crimes and not being able to sustain a viable life in the community. My research areas are in understanding the role of brain function in committing offenses and how to prevent and support those who have disorders, for example, ADHD and more importantly, FASD.
Therapeutic jurisprudence is about, in a very simple way, about using the law to help people. And so there's a substantial body of research now on therapeutic jurisprudence about how the law can be more therapeutic in its goals than the blunt instrument of the criminal law that we normally understand it to be. A mental health court is a form of problem-solving court, again, that rises out of therapeutic jurisprudential principles. The idea is that if the lawyers or the participants that are dealing with an accused in a criminal process realize that there is a mental health challenge for this particular individual, whether that is, like I say, a functional impairment like schizophrenia or perhaps bipolar or something like that, or a cognitive impairment, which might be an acquired brain injury or FASD or other conditions. They can refer that person to the mental health court process.
There is an overrepresentation of those with FASD in the criminal justice system. So we looked at first, how do you easily identify those individuals in the court system or in the mental health system? When you identify them, what can the law do to help them? Whether they are recognized as having a mental disorder, found unfit to stand trial, or can they be sentenced more humanely? And based on that, the mental health court idea was the right one, because we realized that what the research has shown was that it was very difficult for them to be diverted to the not criminally responsible system, and so the best way was to get them sentenced appropriately with the right kind of support.
In a very general way, you might think of a mental health court as a slowing down of the system. And particularly these accused that are in a mental health court generally are committing less serious crimes. So we're not talking generally about violence or sexual offenses. We're talking about minor sort of repeating or recurring crimes. And the idea being that if we can provide that individual with, say, housing, a job, connection to a doctor, connection to other counselors or other support services, that maybe we can stop that revolving door process.
Going forward, there are certain things that are very unique to what has happened in Saskatchewan. To start with, the mental health court, as we're speaking about right now, is probably the only one that we know of that was started with no resources in terms of dollar put to it.
So the accused becoming engaged in the system seems to be a very positive part about this court. Typically, problem-solving courts have graduation ceremonies and clapping and so on in courts that you don't see in a regular courtroom. And that is all about engaging the accused and trying to get them to see that everybody wants them to succeed in life.